Syllabus Part 3, Elective Officials, Vacancies, Succession, Disciplinary Actions. Qualifications: Isabella v. Cumlic 201 SCRA 253 Facts. Initially, Silvestre de la Cruz filed a petition with the Cumlic to disqualify petitioner Larrazabal from running as governor of Leyte on the ground that she misrepresented her residence in her certificate of candidacy as Kananga, Leyte. It was alleged that she was in fact a resident of Ormoc City like her husband, who was earlier disqualified from running for the same office. The Cumlic granted the petition. However, when the commission granted the decision, Larrazabal was already proclaimed the governor. Hence, when she was disqualified, Isabella, who gathered the second highest votes in the said area, sought to take his oath as governor of Kananga, Leyte. The petitioner, however, avers that the Cumlic decision is erroneous when it relied on the provisions of the Family Code to rule that the petitioner lacks the required residence to qualify her to run for the position of governor of Leyte. She opines that under the election law, the matter of determination of the residence is more on the principle of intention, the animus revertendi, rather than anything else. In this regard, she states that her subsequent physical transfer of residence to Ormoc City thereafter did not necessarily erase or remove her Kananga residence. For as long as she had the animus revertendi evidenced by her continuous and regular acts of returning there in the course of the years, although she had physically resided at Ormoc City. Issue: whether or not the candidate who got the second highest vote may be proclaimed as governor when the candidate for such position was disqualified. Held, the Supreme Court held that while it is true that SPC No. 88-546 was originally a petition to deny due course to the certificate of candidacy of Larrazabal and was filed before Larrazabal could be proclaimed, the fact remains that the local elections of February 1, 1988 in the province of Leyte proceeded with Larrazabal considered as a bona fide candidate. The voters of the province voted for her in the sincere belief that she was a qualified candidate for the position of governor. Her votes were counted and she obtained the highest number of votes. The net effect is that the petitioner lost in the election. He was repudiated by the electorate. As regards the principle of animus revertendi, Fabian v. Quirino M. Absence from one's residence or origin domicile to pursue studies, engage in business, or practice his avocation, is not sufficient to constitute abandonment or loss of such residence. The determination of a person's legal residence or domicile largely depends upon intention, which may be inferred from his acts, activities, and utterances. The party who claims that a person has abandoned or left his residence or origin must show and prove preponderantly such abandonment or loss. In the instant case, there is no evidence to prove that the petitioner temporarily left her residence in Kananga, Leyte in 1975 to pursue any calling, profession, or business. What is clear is that she established her residence in Ormoc City with her husband and considers herself a resident therein. The intention of animus revertendi not to abandon her residence in Kananga, Leyte therefore, is nor present. The fact that she occasionally visits Kananga, Leyte through the years does not signify an intention to continue her residence therein. It is common among us Filipinos to often visit places where we formerly resided, especially so when we have left friends and relatives, although for intents and purposes we have already transferred our residence to other places. Whether or not the petitioner is a registered voter of Kananga, Leyte, the petitioner insists that she is such a registered voter based on the following antecedents. 1. She cancelled her registration in Ormoc City on November 25, 1987. And 2. She then transferred her registration to Kananga, Leyte on November 25, 1987 by registering thereat. And 3. She later voted on election day in Kananga, Leyte. We find the version pressed by respondent unworthy of belief. The story is marked by so many bizarre circumstances not consistent with the ordinary course of events or the natural behavior of persons. Among these are The application for cancellation of registration by respondent Adelina Y. Larrazabal happened to be misplaced by a clerk in the election registrar's office for Ormoc City, so it was not sent to the Board of Election Inspectors in a sealed envelope. The inadvertent misplacement was discovered only on January 9, 1988. The voter's affidavit was delivered by itself without any endorsement or covering letter from the election registrar or anybody else. The election clerk delivered the application for cancellation only towards the last hour of the revision day. Allegedly at 4:30 p.m., January 9, 1988, all the members of the Bay had already signed the minutes indicating that no revision of the voters' list was made as of 5:00 p.m. The poll clerk and the third member prepared another minute stating that the election clerk had delivered the application for cancellation at 4:30 p.m. Without any reference to the minutes they had previously signed. Emiterio Larrazabal, who was supposed to have registered in Precinct 17, Mahawan, Kananga, was supposed to have filled up an application for cancellation of his registration in Precinct number 15, Ormoc City at Precinct 17 concurrent with his registration. His application for cancellation was never submitted in evidence. The serial number of the voters' affidavits of the spouses Larrazabal and Precinct number 17 are far removed from the serial numbers of the other new registrants in November 28, 1987 in the same precinct. The most telling evidence is the list of voters, that the chairman and the poll clerk had written in Part 2 of the same, closed by the signatures of both officials, showing that there were only 9 additional registered voters in Precinct 17. Petitioner was not there. It was only on February 15, 1988, or 2 weeks after the election day, that the same registrar certified for the first time that there were 2 voters' lists, the first without the names of the Larrazabals and the second, which appeared only after February 1, submitted by the chairman of the board for Precinct 17, which contained the spouses Larrazabals' names. Failing in her contention that she is a resident and registered voter of Kananga, Leyte, the petitioner poses an alternative position that her being a registered voter in Ormoc City was no impediment to her candidacy for the position of governor of the province of Leyte. Section 12, Article X of the Constitution provides. Relating therefore, Section 89 of R.A. 179 to Section 12, Article X of the Constitution, one comes up with the following conclusion, that Ormoc City when organized was not yet a highly urban city but is, nevertheless, considered independent of the province of Leyte, to which it is geographically attached because its charter prohibits its voters from voting for the provincial elective officials. The question now is whether or not the prohibition against the city's registered voters electing the provincial officials necessarily mean a prohibition of the registered voters to be elected as provincial officials. The argument is untenable. Section 12, Article X of the Constitution is explicit in that aside from highly urbanized cities, component cities whose charters prohibit their voters from voting for provincial elective officials are independent of the province. In the same provision, it provides for other component cities within a province whose charters do not provide a similar prohibition. Necessarily, component cities like Ormoc City whose charters prohibit their voters from voting for provincial elective officials are treated like highly urbanized cities which are outside the supervisory power of the province to which they are geographically attached. This independence from the province carries with it the prohibition or mandate directed to their registered voters not to vote and be voted for the provincial elective offices. The resolution in GR number 80716 entitled Peralta v. The Commission on Elections, et.al. dated December 10, 1987 applies to this case. While the cited case involves a Longapo city which is classified as a highly urbanized city, the same principle is applicable. Moreover, Section 89 of Republic Act 179, independent of the constitutional provision, prohibits registered voters of Ormoc City from voting and being voted for elective offices in the province of Leyte. We agree with the Kumlik and Bank that the phrase shall not be qualified and entitled to vote in the election of the provincial governor and the members of the provincial board of the province of Leyte connotes two prohibitions: 1. From running for, and the second, from voting for any provincial elective official. The petitioner takes exception to this interpretation. She opines that such interpretation is wrong English, since nowhere in the provision is there any reference to a prohibition against running for provincial elective office. She states that if the prohibition to run was indeed intended, the provision should have been phrased shall not be qualified to run in the election for provincial governor. A comma should have been used after the word qualified and after the word vote to clearly indicate that the phrase in the election of the provincial governor is modified separately and distinctly by the words not qualified and the words not entitled to vote. The court finds the petitioner's interpretation fallacious. In the case of Mapa v. Arroyo, the conjunction "and" between the phrase shall not be qualified and entitled to vote refer to two prohibitions as ruled by the Kumlik in relation to the demonstrative phrase in the election of the provincial governor and the members of the provincial board of the province of Leyte. Finally, the petitioner contends that the February 14, 1991 decision of the Kumlik's second division is null and void on the ground that on that date, the term of Commissioner Andres Flores, one of the signatories of the majority opinion, had already expired on February 2, 1991. Commissioner Flores was appointed for a 3-year term from February 15, 1988 to February 15, 1991. In these 3 years he exercised his duties and functions as commissioner, granting in the absence of a statute expressly stating when the terms of the Kumlik chairman and members commence and expire, that his term expired on February 2, 1991 to enable a faithful compliance with the constitutional provision that the terms of office in the Kumlik are on a staggered basis commencing and ending at fixed intervals. His continuance in office until February 15, 1991 has a color of validity. Therefore, all his official acts from February 3, 1991 to February 15, 1991, are considered valid. Issue 1. Isabella can assume position of governor by virtue of Section 6 RA 6646. Ratio: Isabella claims that the Frivaldo and Labo cases were misapplied by the Kumlik. According to him, these cases are fundamentally different from SPC No. 88 to 546 in that the Frivaldo and Labo cases were petitions for a quo warranto filed under Section 253 of the Omnibus Code, contesting the eligibility of the respondents after they had been proclaimed duly elected to the office from which they were sought to be unseated, while SPC No. 88 to 546, which was filed before proclamation under Section 78 of the Omnibus Election Code, sought to deny due course to Larazabal's certificate of candidacy for material misrepresentations and was seasonably filed on election day. He, therefore, avers that since under Section 6 of Republic Act 6646 it is provided therein that any candidate who has been declared by final judgment to be disqualified shall not be voted for, and the votes cast for him shall not be counted. The votes cast in favor of Larazabal, who obtained the highest number of votes, are not considered counted, making her a non-candidate. He who obtained the second highest number of votes should be installed as regular governor of Leyte in accordance with the court's ruling in GR No. 88,004. While it is true that SPC No. 88 to 546 was originally a petition to deny due course to the certificate of candidacy of Larazabal and was filed before Larazabal could be proclaimed, the fact remains that the local elections of February 1, 1988 in the province of Leyte proceeded with Larazabal considered as a bona fide candidate. The voters of the province voted for her in the sincere belief that she was a qualified candidate for the position of governor. Her votes were counted and she obtained the highest number of votes. The net effect is that the petitioner lost in the election. He was repudiated by the electorate. In the Frivaldo and Labo cases, This is precisely the reason why the candidates who obtained the second highest number of votes were not allowed to assume the positions vacated by Frivaldo, the governorship of Sorsogon, and Labo, the position of mayor in Baguio City. The nature of the proceedings, therefore, is not that compelling. What matters is that in the event a candidate for an elected position who is voted for and who obtains the highest number of votes is disqualified for not possessing the eligibility requirements at the time of the election as provided by law, the candidate who obtains the second highest number of votes for the same position cannot assume the vacated position. It should be stressed that in GR number 88,004, the court set aside the dismissal of SPC No. 88 to 546, and directed the Cumlic to conduct hearings to determine whether or not Larrazabal was qualified to be a candidate for the position of governor in the province of Leyte. This is the import of the decision in GR number 88,004. Thus, the court ruled in the case of Labo, Jr. v. Commission on Elections. Finally, there is the question of whether or not the private respondent, who filed the quo warranto petition, can replace the petitioner as mayor. He cannot. The simple reason is that as he obtained only the second highest number of votes in the election, he was obviously not the choice of the people of Baguio City. The latest ruling of the court on this issue is Santos v. Commission on Elections, decided in 1985. In that case, the candidate who placed second was proclaimed elected after the votes for his winning rival, who was disqualified as a turncoat and considered a non-candidate, were all disregarded as stray. In effect, the second placer won by default. That decision was supported by 8 members of the court then, with 3 dissenting and another 2 reserving their vote. One was on official leave. It would be extremely repugnant to the basic concept of the constitutionally guaranteed right to suffrage if a candidate who has not acquired the majority or plurality of votes is proclaimed a winner and imposed as the representative of a constituency, the majority of which have positively declared through their ballots that they do not choose him. Sound policy dictates that public elective offices are filled by those who have received the highest number of votes cast in the election for that office. And it is a fundamental idea in all republican forms of government that no one can be declared elected and no measure can be declared carried unless he or it receives a majority or plurality of the legal votes cast in the election. The fact that the candidate who obtained the highest number of votes is later declared to be disqualified or not eligible for the office to which he was elected does not necessarily entitle the candidate who obtained the second highest number of votes to be declared the winner of the elective office. The votes cast for a dead, disqualified, or non-eligible person may not be valid to vote the winner into office or maintain him there. However, the absence of a statute which clearly asserts a contrary politics and legislative policy on the matter, if the votes were cast in the sincere belief that the candidate was alive, qualified, or eligible, they should not be treated as stray, void or meaningless. In sum, the court does not find any reason to reverse and set aside the questioned decision and resolution of the Cumlic. The Cumlic has not acted without or in excess of jurisdiction or in grave abuse of discretion.